Hello and welcome everyone to the main event. My name is Nita Sani and I'm really pleased to be joined by our special guest today, Debbie Sadler. Hi Debbie, how are you doing?
Hi, I'm fine, thank you. Thank you very much for having me. I'm a bit nervous, but looking forward to our conversation.
Well, there's nothing to be nervous about. We are a room where we share knowledge and you are the expert. You have a background in employment law and we at the main group have a background in people, businesses, not-for-profit organizations and helping them align to be engaged, productive, and most importantly, a happy working environment. So employment law updates are absolutely key because that essentially is the foundation of the space that's created for people.
Absolutely, lots of synergy there, yeah.
So this is such a good time. This has been by far our most popular webinar sign up. I think we've had nearly 200 different organizations sign up today. And why do you think that it's such a, because we've done employment law updates before when it's not been, you know, as popular. What do you think it is about the employment law updates that are happening at the moment that's so key for organizations to think about?
I think particularly with the new duty to prevent sexual harassment, there's been an awful lot of publicity, the Me Too movement, lots of awareness of unfairness generally across the wider society. And I think organisations are keen to ensure that they prevent harassment, prevent discrimination in their workplaces and do the right thing. So I think the new duty to prevent sexual harassment has kind of hit the spot, if I can put it that way, in terms of timing. And people, organisations want to know what they've got to do. They want to look after their workers and so they're interested in knowing what the new duty entails.
Fantastic. Well, I know that you've got all the knowledge and we're going to be running through it quite systematically. So just before we get into the detail, I just wanted to do a little bit of housekeeping for everyone in case you haven't been to one of our law forums before. So with the main event, we try to keep it about 45 minutes. We know that everyone's time is precious. So to make it effective, and we promise to give you information and knowledge that you can take back to your organization and apply straight away. We also record this session, so if you feel that you want to make notes or you want to watch it again, please know that we'll send out a recording at the end of the day. Now, this session is for you, for everyone that's signed up, who's turned up today. You know, this session is for you to get time with Debbie and myself to potentially get your questions answered now. So what we've done is we've made a chat room available and I've already got a hello in there from Elizabeth. Hi, Elizabeth. I'm also going to type a little comment to say hello, just to show everyone how easy it is to sign up. So if you can hear us, if you're in the room and you're ready to go, just give us a little hi and let us know what your position is in your organization. So when Debbie and I are speaking, we can make sure that we're speaking from a frame of reference that will benefit you. Also, we always like to get the temperature of the room. So today, Debbie and I discussed, you know, the poll that we felt would be helpful to understand that. So our question to you all today is, what area is your biggest concern when we think about the upcoming employment law changes? So, of course, we know sexual harassment is right around the corner. So that's one option. The new employment bill that Labour are bringing in, and Debbie, you mentioned timing-wise, it's actually coming out tomorrow, isn't it? So the sort of the overview of it will be released tomorrow, but it won't come into legislation for about a year. Is that right?
It will be subject to consultation, so there'll be different parts of it that would be introduced at different times, depending on the complexity of what is being discussed. Yeah.
So today we can cover what we think might be on there. The first one is the unfair dismissal as a day one right. That actually is the most popular, and you said this would be popular, didn't you? 53% of the room are saying this is our concern. The other areas are the right to switch off, the employment tribunal reforms that are coming in, and potentially, and also removing discrimination from the workplace, which actually links into what we're talking about today with the sexual harassment duty as well.
Yeah.
So I think without further ado, we want to jump straight in and start sharing what we know. Now, what we said we would do is to start with talking about the worker protection amendment of the Equality Act. So, Debbie, I always say that what I love about working with Draper and yourself and the rest of the team is how accessible, you make the law. So enlighten us into what this new update means. It's starting 26th of October, is that right?
It is, yes. So the very catchily entitled, as you say, Worker Protection Amendment of Equality Act 2010, Act 2023, is essentially an amendment to the Equality Act that has been in existence since 2010. So it's a tweak, it's a fundamental tweak, but it is a tweak. So since 2010, we've had a definition of what sexual harassment is, and there's been an obligation to take steps to ensure that workers are protected from it. But the new legislation shifts that emphasis. So it's not a new definition of what constitutes sexual harassment, but it's a new approach. And from the 26th of October, employers will have a proactive, preventative duty to prevent sexual harassment in the workplace. So it's quite a fundamental shift. It's not a wait until we receive a grievance approach. It's a assess, analyse, proactively determine how to avoid those things happening.
So putting steps in place that are deliberate, everyone's made aware of them, you train them out, you talk about them, you put them on your intranet. It's really important that employers make positive noise about the fact that they've acknowledged this and they're putting the steps in place.
Yes, and really, really importantly, this is an ongoing duty. So it's not a matter of producing a policy, adding it to the handbook and then ticking a box. This is a proactive, continuous duty to assess what are the risks in my workplace? How can I mitigate against those risks? How can I reasonably prevent sexual harassment happening in my workplace? So it is something that is going to require time and energy and effort and some cost, I'm afraid. So if people remember when we had the data protection regulations come in, there was an awful lot of what do we need to do? It is something that people need to be aware of, employers need to be aware of, and they do need to assess what the risks are and mitigate against them.
And we're going to go into that in a bit more detail, aren't we? So we can actually give a step-by-step guide to how anyone attending or listening to this session later can actually apply into their worlds. So who does this apply to? Is there a criteria for a size of organisation? Who would this apply to?
Essentially, all organisations are bound by this legislation. So if I'm talking about employers, I'm talking about it in the broadest sense. So the equality, we've got lots of different pieces of legislation in the employment law world. The Employment Rights Act applies primarily to employers and employees. The Equality Act, which this legislation is amending, is much broader than that. It's a public policy piece of legislation, anti-discrimination legislation. So it applies to employees, workers, apprentices, members, partners, the broad spectrum. So if I'm talking about employers and employees, forgive me, I'm misusing the terminology. It's in the broadest sense that we're talking about.
Okay, so anyone who's connected and doing work for an organisation.
Yeah, in the working environment, Sorry.
Yeah, and so you mentioned that the original or the last version was produced in 2010. And somehow that was nearly 15 years ago now, which blows my mind. And yet, still to today, I was looking at some statistics, Debbie, and they're shocking. More than half of women believe that women in their workplace are at risk of sexual harassment. More than half. And nearly 1 in 10 feel that the risk is quite significant. I mean, on one hand, it feels like we've made such great strides, and yet 25% of women in the workplace feel that they are consistently exposed to sexual harassment. I mean, this is shocking.
It is shocking, and it's a failure of legislation. It's a failure of public policy. We shouldn't be in this situation now. I mean, the equal pay legislation originally came to pass in 1970, and then the Sex Discrimination Act was 1975 or 76. So, these policies have been in place for a long time. But now they have gained traction for a variety of reasons, and the government is going with that. So the previous government introduced this amendment, and we're waiting for this employment bill. We'll see what that brings. And that's due to be published tomorrow, hopefully.
Well, we can certainly share that with everyone in the room today and anyone who's signed up. And I imagine we'll probably be doing a part 2 in a few months down the line when we've got more insight into that. Now, where would an employer start? So if we're sitting here today and we've got till the end of the month to put everything in place, and as you said, be really proactive and consistently checking in on making sure employers have created that protective environment, where would an employer start today?
Okay, so the first thing I would suggest that employers do is have a look, Google the EHCR website. So the Equality and Human Rights Commission has produced guidance, technical guidance, and an 8-point plan that employers should follow. It's written, it's not legalistic, it's relatively easy to read, and it's really useful background and information for employers to refer to. And the 8-point plan in particular is really useful in terms of when an employment, if you're in a tribunal, and hopefully you'll never get there, but if you're ever in an employment tribunal and you need to show that you've taken reasonable steps, what is considered reasonable? So I would definitely refer them to the EHRC website, really useful place to start. In terms of the guidance that they have provided, as I say, there are 8 steps. I think the most important step that an employer could take initially is to risk assess their environment. So the risk assessment needs to determine where the risks of potential sexual harassment are. And that will vary massively from sector to sector, from size of the organisation. And the duty is to take reasonable steps. So what is reasonable for a massive international conglomerate is very different to a charity or a small employer. So it's about what's reasonable. It's not one size fits all, it's reasonable steps. And the risk assessment is the employer's opportunity to engage employees. You know, there's a really positive way of identifying what these risks are, because depending on what their roles are, they will know better than the CEO, for example, of the day-to-day issues that they're facing. So engaging staff not only identifies the potential risks potentially in a better way, but also sends a message. You know, we are reasonable employers. We are taking this seriously. We are concerned about your welfare. We want to engage you in this process. So it's
what would engagement look like? Would it be polls? Would it be face-to-face conversations? Like what sort of engagement are we talking about here?
All the above. So it could be a poll. Again, we come down to the size of the organisation. You know, if you can all fit in one office and there's 4 of you, a poll seems slightly unnecessary and contrary to what you're trying to achieve. If you have lots of different teams, a large organisation, a poll would be really good, and also has the benefit potentially of being anonymous, because we're talking about sensitive issues here. And if you're saying to people, we're trying to do a risk assessment, we want to determine where the risks are, inevitably you may get more information than just, nighttime working is tricky, and I don't like hanging out with certain people. So it's really a matter of how to get that information, how to convey the message that you are taking this seriously. So all of the above.
Yeah. Fine. Now, we've just got a little request from the room that could we share the link? Absolutely. What we'll do is when we send out the recording for today's session, we'll put the link on there as well so that you can all access that. Also, we'll have Debbie's and my details, which will allow you to reach out to us afterwards if you have any other questions. But if you have areas of concern or situations that you would like us to talk about now, please feel free to put it in the chat box. You can actually put it in privately, so your name won't be mentioned, but we can, maybe even give you the solution straight away. But if you don't feel comfortable doing that, we're both available outside of this session as well. And obviously Debbie is the employment law specialist, so she'll definitely know how to be able to apply the law. And I guess my 30 years is more about what businesses and what not-for-profit organizations are doing in practical terms, which is why I think it's such a good match of having me asking the question as a business leader, as an employer who is responsible also for the safety of my employees, but also when we put temps out and interims out into organisations, it will extend to them too. We'll want to do the due diligence to ensure that anywhere where our employees work have considered the sexual harassment laws and the requirements of those organisations as well.
Yeah, absolutely. Yeah.
And so are we looking right down to language used on our website, language used in contracts, how we engage, what sort of training, like how deep is this going to go and how deep should it go?
Well, it's very interesting because the guidance and the information that people will be able to see on their link, one of the recommendations is an anti-harassment policy. And actually the detail that the EHRC goes into in relation to those policies is quite extensive. So it is very much sending a firm message that zero tolerance of any kind of sexual harassment. Training, I think training is really, really, really important, because in order to, again, it's got the advantage of conveying the message of how important this is. And also you are giving people a confidence either to report concerns and also to deal with concerns as well and respond to concerns in the right way. And I think language is very important. There are lots of cases where language has been used by people who think it's fine, but sexual harassment is about the purpose or effect of the conduct. And, you know, we're focusing on language here, but it doesn't have to just be an oral or written piece of language. It can be acts as well. It's a very, very broad remit in terms of what constitutes sexual harassment.
We've actually been asked by a few of our clients to put together a training program. So if anybody's interested in that, we would, you know, love to be able to deliver that for you as well, or just give you guidelines of what we're looking at training, because it's a bit like, I always think about most organizations, they have all these policies, they talk, hey, you know, you joined our organization, here's a list of all of our policies, and then they sit on the website and really, you know, not a lot happens. I mean, these should be brought out at least once a year and talked about individually. Like, how would you say employers would engage with their teams? You talked about training. What would be a good frequency of engagement?
Well, again, I think it depends on the risk assessment, because if you're in an area of work where actually is quite static, you're not engaging with third parties particularly, there's not so much remote working. If you are very much aware of what's going on in the environment, actually your risks probably aren't so significant. If you are identifying lots of significant risks, then you're going to, I would have thought, need reasonably regular feedback in terms of what those risks are, how the policies are working, you know, the things that you're implementing, the reasonable steps that you're taking, how are they working? If they're not working, then we need to know that pretty quickly so that we can address that. If it's a matter of the steps are fine and there's no problems, there's no grievances, you're not getting any reports of sexual harassment, then I would have thought that probably at least once every year you should be maybe doing refresher training, doing new polls, just getting that interaction going with your employees and your staff to find out how things are working, whether there are any additional concerns that you need to be aware of.
Yeah, that's really what it's about, isn't it? It's not about creating policies and it turning into wallpaper, that it's just there and we stop noticing it, but we keep it alive, we keep talking about it. And it's quite interesting what you said, it depends on the size of the organization, the engagement, but what that actually brings in is the fact that managers really need to be trained on this. Absolutely. Because every team is a little team within a bigger team. So actually, if you're an organization of 5 people, each management team is probably its own little organization of 5 to 10 people. So if they can treat their world with as much duty of care and consistency, and then hopefully the system should work no matter how big the organization is or small.
Yeah, I mean, this definitely needs to be introduced top down and also get the feedback from bottom up. So it needs to be a joined up approach. But banter, I mean, there are so many cases where office banter has caused problems. So the other thing about sexual harassment is you can have situations where people have not objected to the conduct, and then something happens and suddenly they object to the conduct. So the definition is unwanted conduct of a sexual nature. And unwanted is the key here. So office relationships, can lead to sexual harassment allegations and situations. So it really is a matter. The workplace isn't static. I think that's the key point. And employers need to be aware of that and risk assess accordingly.
Well, it's quite interesting you talk about the workplace relationships, because there are some different schools of thought. Some organizations have a rule that you sign when you join, they're completely off the table. Is that right? Is that still something that exists out there? How do employers tend to approach that?
Yeah, so many years ago, there seemed to be a phase of people introducing love contracts. So workplace relationships were purportedly banned, but if you had a workplace relationship, you had to sign a love contract, which had no legal standing, I should say. It was something that I think was originally imported from the US. All employees have a right to a private life, and no employer can prevent them from doing that. You can have rules around, if you have a relationship in the workplace, you still need to treat each other with respect, you need to treat each other professionally. We still have boundaries and expectations in place, but you can't prevent people from having a relationship. And people spend so much time at work, it's quite common for that to happen. I think the important thing is, if you have a good relationship with your employees, then hopefully they would feel able to talk to you about it, or you could talk to them about potential risks. It's really that good basis, good working relationship, which is key to all employment law, fundamentally.
Yeah, and then that again becomes the approachability of managers and their ability to communicate and engage and create that safe space for employees. We actually got a really good question from the room. Barbara asks, what about off-site events that are organised by workers? So not necessarily organised by the employer, but actually the informal ones that are organised by workers. Where do they sit?
Yes, so very good question. So harassment, and I'm going from case law that we've had. We've got this new duty, but as I say, the definition of harassment hasn't changed. So we can take it as read that the case law and the information that we've gained will still apply, even with the new duty, perhaps more so because of the new duty. So the duty to take reasonable steps to prevent harassment is in relation to the working space, the working environment. So that's not just the office, it is work-related activities. So the office Christmas party, we're coming up to that time of year, that is rife and should definitely be risk assessed as part of any risk assessment. Where the event is organised by workers, I'm sorry to give a blurred answer, but it would be very fact specific fundamentally. If it's a leaving do, so somebody is leaving and one of the colleagues organises an event, a leaving drinks do, that won't necessarily be associated with the work because it's a social event, it's organised by colleagues, stroke friends, it's not necessarily officially endorsed by the employer. So it's not necessarily going to fall into the workspace and to the laws around harassment. But it is very specific.
What if there's a manager at the event?
Well, if we took a different event, so for example, somebody is retiring and they've been there for a long time and the employer officially endorses that event. So, Bob is retiring, let's all go and say goodbye to Bob. That is much more likely to be a workspace event where this legislation will apply, as opposed to there's a single team, one of the members of the team takes it upon themselves to organise a social. That's probably less likely to fall within the legislation. But it's not completely black and white. It is fact.
No. Yeah, and the fact is that the challenges will still come back to the workplace. I mean, I think the responsibility of the employer may not be, to be liable, but they will still have to probably navigate the challenges that have arisen.
Because it can still lead to grievances. You can still end up with a grievance. We went out on this work do, something happened, my boss now is treating me differently, or my colleagues treating me differently. So it's not a matter of saying, oh, that's nothing to do with us. Anything really to do with colleagues working together, as you say, is likely to come back into the workspace. And then we may have a duty to, well, apart from anything else, best practice is to foster good employee relations. So, it could be taking them for an informal coffee and sitting them down and trying to get them to sort it out. So not necessarily a formal grievance process, but if your employees aren't working well together, that's going to have an impact on the business.
Yeah. It's not great because there's very clear ways that every employer can decide to approach it, but it is great because every situation won't necessarily fit into a box. So I guess it's planning ahead, experience. Does experience create precedent? So if an employer has a situation, it's dealt with in a certain way, can that then become an expectation of future? And does that have to be relayed out to employees as well?
Yeah, so for example, in disciplinary proceedings, so if we have somebody who is accused of sexually harassing another employee, that's bound to lead to a grievance process and probably a disciplinary as well. So in a disciplinary scenario, it's really important that we treat everybody consistently. Now, of course, there can be variations, because if you're dealing with somebody who's never had a disciplinary sanction in the past, they've been there for 20 years, there are particular circumstances. Sexual harassment, I mean, is almost certainly going to be gross misconduct potentially. But depending on the circumstances, it wouldn't necessarily lead to gross misconduct dismissal, for example. But consistency is really important, because otherwise you face challenges that you are treating people unfairly if you are inconsistent with the way that you approach things.
Yeah, this is a lot of headspace, isn't it, for employee? Well, and it should have already been in place. So actually, everything that's coming up now isn't something that's new. It's more defined, I suppose, is yes. What's happening now.
Yeah, so these are general good pieces of practice, not necessarily linked to the new duty to prevent sexual harassment. So if employers have good practices in place, then really they're just going to build on those as part of this new duty. So good communication, training, transparency, ways of reporting concerns, which is really important given the nature of the sexual harassment brief or subject matter. It's really important that individuals feel confident in being able to report those concerns and know that they will be taken seriously, dealt with confidentially, and that support will be put in place in order to deal with whatever those concerns are.
So the best time was back then, but the next best time is now. Review, revisit, refine, and get to where you need to get to, and get the advice, get the training. And I think, isn't it so that, because we're going to go into what happened when it goes wrong, is it fair to say that if best practice is followed and documented, that any tribunal or anything will take that into consideration?
Absolutely. I mean, as a general premise, so much legislation around the employment sphere is about what's reasonable. Because as we talked about earlier, reasonable for one business isn't necessarily reasonable for another. So it may be reasonable to dismiss somebody in one situation, but not necessarily in another situation. Reasonableness is just part of the process, because these laws apply to everybody, every employer.
So we've been talking a lot about what it takes to get it right and get the right structures and education in place. What are the implications financially and legally of an employer getting it wrong?
Okay, so there's no standalone claim that an employer has failed to prevent sexual harassment. So it's a new duty, a new obligation, but an employee cannot bring a claim saying, my employer, and as I say, I'm using employee and employer, but it's the wider sense. My employer hasn't taken reasonable steps to prevent sexual harassment. So the way an employee would bring a claim would be to say, I have been sexually harassed. And if that claim succeeds, a tribunal then must consider whether the employer has failed to take reasonable steps to prevent that harassment taking place. And if that claim succeeds and the tribunal finds that reasonable steps haven't been taken, then compensation can be increased by up to 25%. So when you think
what do those numbers look like?
Well, I was going to say, when you think that compensation for discrimination is uncapped, that could potentially be quite a lot of money. So I was doing some research as part, preparation for this chat, And there was a case some years ago now against Lidl, where an individual was found to have been sexually harassed, and she was awarded £50,000. Now, everything's fact specific, but if you're timesing that by, adding another 25% on that, that's potentially a big sum of money. Now, they're not all at that end of the spectrum. It's all fact specific, but potentially it is a lot of money that would need to be paid out. But more than that, it's reputation as well, because these are the types of claims that attract public interest. The press can, all tribunal claims pretty much are public hearings, so the press can turn up. If your name is in the paper associated with sexual harassment, it's going to damage your reputation with clients. You're not going to attract the best talent. So it is going to have quite an impact on your business potentially.
Yeah, and people will leave. People talk with their feet, and they will leave an organisation.
Yeah.
So it's so many ramifications of getting it wrong, and hopefully with your help today, Debbie, and with the 8-step checklist, so many ways for employers to demonstrate how they're working to get it right and following best practice.
Yeah.
So what I'd love to do is to sum up everything we've talked about in terms of sexual harassment, because I'd love to go to the poll and look at the other popular votes that have come up today. But is there anything else in terms of the sexual harassment laws that you feel our audience should be aware of today?
So I think fundamentally they need to be aware that this is a shift. This is a proactive position, a proactive approach that needs to be taken. The purpose is to prevent. It's reasonable steps. So it's not originally it was all reasonable steps. The all has been removed, which from a legal perspective is pretty significant. So it's reasonable steps. What are your resources? What is the nature of your industry? What are the risks? So risk assessments are fundamental. They are really, really important. Engaging your employees, really important as well, because you're communicating your concerns, you're getting the feedback, you can then put steps in place. Training so that people know, so particularly for line managers, if they are presented with these concerns, they can confidently deal with them. Not just say, go and speak to HR, nothing to do with me, confidently deal with them. And they know about confidentiality as well. It's really important. Confidentiality is key. Have reporting procedures in place, and support. Can you offer counselling? What steps can you take? But crucially, these concerns must be raised in good faith, because I'm sure you have come across this and I have come across this. Sometimes really serious allegations are made which are not in good faith. So yes, we need to support, but we also need to have a reasonable approach so that we don't exclude anybody who has been accused of harassment instantaneously. There has to be a bit of balancing going on there. Yeah.
So there has to be an element of getting the story from both sides, of trying to look at the big picture. Doesn't mean you don't take the allegations seriously, but you do your proper explorative work. And it sounds obvious, but of course, that's really key. We've got a question from the room about how can an organisation conduct a risk assessment? Are there any templates available or questions that could be asked?
So I'm not aware of any templates at the moment. Certainly the EHRC hasn't produced any. I'm sure as this legislation embeds, there will be a raft of risk assessments. The Health and Safety Executive has a broader risk assessment with the background of health and safety, obviously. It may be that those could be adapted. But I think primarily it's a matter of, I think if you engage your staff, then they will give you a sense of what the risks are. And if
the answers are in there already.
Yeah, if you're in hospitality and your staff are mixing with lots of third parties in an environment where there's alcohol and entertainment and people letting their hair down, your risk assessment really is, how do you communicate your policy to the people who are coming to the events? Do you have notices up? Where do the staff think there are particular concerns? So I'm not necessarily answering the question direct, but the employer is best placed to know what their workplace is like.
I think what you're saying is one size doesn't fit all in terms of these risk assessments. It is standing back and looking at your organization and thinking, right, what's our office structure? Where do our people go out and interact?
Yes.
Even things like, are the kitchens and the toilets in places that, can interact? There's so many different areas where sexual harassment could occur and then you're so right, Debbie. So much of what we do, and we sit there as senior leadership or HR and scratch our heads, but actually if we just asked our people, we would get so much insight and knowledge. That's probably the best place to start. Yeah. So let's talk a little bit about the employment bill that's coming in. So in our poll at the moment, the new employment bill, unfair dismissal as a day one right is in at 54%, so half of the room, so about 100 organizations are saying, this is on our minds. This is something we really need to get our heads around. Now, obviously today, Debbie, we can only speculate and give some insights, and we'll probably do one with more detail when we get the final bill in place. But what would you say employers should be thinking about when it comes to this unfair dismissal and day one rights legislation that could potentially come in?
Yes. So just to summarise where we are at the moment, once an employee, and we are talking about employees here, not workers in the broader sense, but once an employee has 2 years continuous service, they have the right not to be unfairly dismissed. So at that stage, an employer can only lawfully dismiss them for one of 5 statutory reasons, and subject to a fair and reasonable process being followed. So the proposal is to remove that 2-year limit. So the minute an employee starts with you, they then have the right to claim unfair dismissal. Now, we have been told that employers can use probationary periods. So there will be a whole new focus on probationary periods going forward. A probationary period historically has been a 3-month, 6 months, sometimes 12 months, but less so 12 months, more probably 6 months, I would say. During which time the employer and employee can decide whether they are a good fit for the role. So whether they've got the skills, the right aptitude, they're a cultural fit for the organisation. And often during the probationary period, an employer will decide that they're not the right fit, or the employee, it works both ways. But there will be, I think, a new focus on that probationary period, because that, as we understand it, that probationary period can still work in the same way. So during the probationary period, the employee won't have the day one right to claim unfair dismissal, or this is where we're not quite sure, we haven't got the detail, or the day one right will come into effect, but it will be subject to that 6-month probationary period. So it'll be kind of a holding period of time. But again, we don't have the detail. And I think I've certainly seen contracts without a 6-month probationary period or any probationary period in them, which it's not required that contracts have a probationary period. But I would certainly be recommending that going forward, a 6-month probationary period is included, because I think it will take on a whole new meaning. Okay, so day one rights, but most likely subject to a probationary period, which means they're not really day one rights at all, are they? Well, we don't know. This is the frustrating thing, because it could be that during the 6 months you could lawfully dismiss for capability, so the way that they are performing a job, or conduct, for example. But there may be tweaks, there may still be a process that we have to follow. We just don't have the detail yet. And I think any employer that wants to follow best practice on this anyway, from now, I think there's so much in note taking, having weekly updates, having that written down of an email summarizing the conversation, areas to focus on, areas that are working, areas that need more training. Just like having everything documented in a just very simple note form, but something that you can look back at and see the way the story has gone. It's not just a knee-jerk reaction. And I think the majority of employers,
want in good faith for their hires to work out. I know when we're placing people, the time, the money, the effort spent, nobody wants to dismiss somebody because they've changed their mind. It's usually a reason. And I always say nobody wants to go to work feeling like they're failing. So have those conversations, have that openness and ability to communicate, and hope that in and of itself should start to prevent some of these situations getting taken to court.
Yeah, so I mean, coming back to the best practice point, because the ACAS Code of Practice relates to dismissals for capability and conduct. So at the moment, if somebody doesn't have the 2 years service, some employers will take a commercial view that they won't follow that process. But going forward, as a day one right, subject to whatever this technicalities are around the probationary period, that process is going to have to be followed. So it will require more time. It's best practice anyway, as you say. And, you know, best practice, if you're, once you've gone through that hire process, you've gone through the interview process, you've invested that time, it makes absolute sense, as you're saying, to have that conversation with the employee. If they're not quite performing to the right level, unless you're communicating that with them, they can't fix it. So communication, you know, everything comes back to communication at the end of the day. But if you're having those
management training, I really do. I still think it. Management training was our most popular training course last year. And actually, I think with everything that's happening, it just reminds us that, you know, good managers with exceptional communication skills and emotional intelligence is key.
Yeah.
You know, not just knowing the job.
No, but confidence is key as well. And as you're saying, with the training, it gives managers confidence. Because in lots of businesses, managers are really good at doing the job that they're employed to do, and then they're promoted and suddenly they're expected to be good managers as well. And some of them are, but some people need a bit more support. So training is fundamental, because I've certainly worked with clients who have almost been scared. They've been presented with a problem and they just haven't known what to do about it. So they
haven't got the tools.
Put it on the too big to do at the moment pile, which just, it compounds it. You know, that's pretty much always the worst thing that you could ever do. So it's just that confidence and that training, and also in terms of reasonable steps, not just for the prevention of sexual harassment, but across the board. You know, if you're taking reasonable steps to show that you are a proactive, positive, inclusive employer who values your staff, then you're less likely to end up needing to talk to people like me, and more likely to have a productive, happy workplace, which is fundamentally what you want.
Talk to people like me to bring in and train more people to grow your successful, happy organisation. Well, Debbie, we've got quite a number of questions and comments in the chat room, which is fantastic. Thank you to everyone. We've got a few on probationary periods, and then if we can, I'd like to go back to some questions we have around sexual harassment. So just to cover off what we're speaking about in terms of probation period, Lancelot has asked, does probation period apply for contract workers?
So another of the proposed changes is to do away with one of the categories of individuals. So at the moment, from an employment law perspective, we have three different categories of worker. We have an employee who has the most employment law rights, a worker who's kind of a hybrid, and then the genuinely self-employed who has the least amount of employment law protection. So one of the proposed changes is to combine employee and worker status into one, and then to potentially allow both categories of workers to have the great big raft of employment law protection. So if that happens, absolutely, the probationary period issue will apply to a worker as well.
Okay. And we also had a question around whether there is a reasonable length of probation. Would 12, will employers be potentially increasing their probation periods? Would 12 months be seen as unreasonable in this scenario?
As far as we are aware, the maximum will be 6 months.
Okay.
The devil will be in the detail, but the headlines has been 6 months maximum, which is why I've referred to that. Yeah.
Okay. Well, we are coming up to the end, but I've got a few more points I'd just like to discuss with you, and just to point out as well. So if you're looking at the chat box, somebody, Lenka has shared something from BBC iPlayer, which is a podcast saying, is this sexual harassment? something that she said she found very useful. And Sarah has mentioned that when it came to risk assessments, good old ChatGPT was a great place to start to then edit and make your own. And I agree. I think ChatGPT is, just kind of like, give me an outline that I can then, build on. Erin asks, what kind of questions can you ask employees to get the most from? I think open questions are very key. So rather than the yes and no, make sure your questions, you've got some that are asking them for scenarios. What would you say to that, Debbie?
Oh my goodness. Well, open questions are always going to get the most information, which sometimes is a pro and sometimes is a con.
True.
I think in terms of reasonable steps, it's about how to reasonably assess what the risks are. So if you are comfortable, and a lot will depend on your workplace, of course, but if you are comfortable giving employees the opportunity to properly feed back to you what the risks are, then you're going to have more tangible and useful evidence to assess what those risks are. This isn't a tick box exercise. This is a matter of reasonably assessing, and a tribunal will objectively determine, if you're in that dark place, whether or not you've met that duty. So you need to, I always think it's useful to play devil's advocate a little bit. And if you've sent people 10 questions and it's yes or no, are you really going to show that you have taken all reasonable steps to assess the risks? Whereas if you've sent some yes or no questions and then a box at the bottom, for example, saying, is there anything else you think we need to be aware of? Yeah. Possibly, firstly, you should get more useful feedback. And thirdly, more likely to show that you have been reasonable. I mean, there's always a balance. If you're sending people a 20-page questionnaire, you're not going to fill it in. It has to work for everybody. But the main purpose, I think, is to show engagement, flag the key areas, because you can always drill down at a later point. And as I say, this is a continuing duty. So if you get a headline and take steps now, it's worthwhile reassessing whether they are working further down the line. Okay.
Thank you. Now, Debbie, we have gone over our 45-minute mark, but we've still got a couple more questions, which I'd love for us to be able to answer. So if you're in the room and you're willing to stay on for a little bit, please do, because these are some really good questions. Might give you the answers you're looking for. So we have a question here that says, if a claim of sexual harassment is made against an individual and that individual is summarily dismissed, could the individual still bring a case against the organisation for the fact that the harassment happened in the first place? I mean, that is quite a tricky scenario.
Quite a detailed question, isn't it? Yeah. It sounds like there might be some concerns around that situation. So claims for discrimination, not just harassment, can be brought against the company, so the employer, and individuals as well. As a default situation, the employer is liable for the actions of its employees. And I'm using, as I say, employer and employees in the broadest sense here. There are situations where an employer can be found to have taken all reasonable steps. So it's a different defence than the one that we're talking about for sexual harassment. But if an employer can show it's taken all reasonable steps, the employee can still be liable. So it doesn't matter if the employee has left the organisation, it's about what they did whilst they were employed in the organisation. So I don't know if that completely answers the question, but hopefully it does.
I was going to say, let us know if that answers your question. And if not, we can take this off the live and give you more insights. We've got one more question. I know I keep saying just one more, but this actually, a few people have asked this. Could the 6-month probation period be extended if it's about improving performance or to support people, or, is it, I know you said it will be around 6 months, but could there be an option to extend that probation period?
We don't know. I mean, contractually, so you've got statute, which is what the law says, and then you've got contract law. So there are two different types of law. So you could have a contract that says 6 months subject to extension, which is the common. Contracts are normally drafted reserving the right to extend the probationary period if necessary. So it doesn't, we'll have to, the devil will be in the detail, but I don't think it will preclude necessarily employers from extending the probationary period contractually, but it may mean that the unfair dismissal legislation will kick in from the end of 6 months, regardless of what the contract says. So there may be a contractual benefit to having that in there, but it might mean that you still are subject to the ACAS code of practice, depending on what the reason for the dismissal would be at that stage.
Debbie, thank you so much. I feel like we've pushed and pulled you in all directions when it comes to employment law today, and you have handled it so well. Thank you so much for your time today. Everyone in the room, thank you everyone in the room for your insights, your questions, for coming along today and showing that this is something that's so important to you and you want to get right in your world. We are out of time. So at this point, I'm going to just show everyone what the poll results were. In the end, the sexual harassment updates, removing discrimination from the workplace, which is similar, amounted to around 35%. But the unfair dismissal at day one rights is definitely one of the biggest concerns. So, Debbie, maybe we do this again and we focus on that once we've got the new employment bill in front of us.
Yeah, be my pleasure. Yeah.
Wonderful. Well, thank you for now, and thank you everyone. And we're getting lots of feedback saying everyone's really appreciated it. So really wonderful. Well, in that case, we'll say bye for now, and we'll see you again very soon.
Thank you. Bye.
Thanks. Bye.